100 billion US dollars. This is the inward remittance amount which India has received in 2022. That means this is the amount which NRIs have sent to India. Now this amount will tell you how important Indian diaspora is to Indian economy. They are giving much needed leverage to Indian economy. Then who is NRI? In simple layman terms, we can say that he is a person who has migrated to another country. But there are two acts which governs, that's FEMA, Foreign Exchange Management Act, and Income Tax Act. And in this video, we will study the definition of NRI, focusing more from the point of view of Indian taxation, because that's where most of the confusion lies. So, welcome to this NRI series, and let's start with the basic definition of who is NRI. Let me tell you, there are two types of taxpayers. One is resident taxpayers, another one is non-resident taxpayers. Now the obvious question which is coming in your mind is, I am an NRI, why will I pay tax? Yes, foreign income of an NRI is never touched, it is never taxed, but Indian sourced income of a non-resident is taxed. And in some circumstances, if the residential status changes and NRI ends up becoming resident for that year, then even there is a possibility that the foreign income of NRI is going to be taxed. So it's very important for us to understand under what circumstances we become resident or non-resident. Let me also draw your attention to two most important points. One, it's quite possible that if you are resident of one country, you may end up becoming resident of another country. I'm not talking about physical presence, it is strictly for tax purposes. So when you end up becoming resident of different countries, then we always refer to DTA, otherwise double taxation avoidance agreements, and there are some reliefs which we will discuss in our coming series. And this also tells us we should be aware of the conditions which makes us resident in a particular country. And another most important point is, there is no fixed definition which you can find in Income Tax Act which defines who is NRI. So we have to see what makes an individual resident, because there is a definition for resident. So whoever is not resident will end up becoming NRI. Section 6 Clause 1 of Income Tax Act, it specifies two basic conditions. One is stay of 182 days or more. If any person has stayed for 182 days or more, he becomes resident. Second condition is, if anyone's stay in previous year is for 2 months, 60 days, and immediately 4 years, if you take this 4 years block, immediately preceding that particular previous year, if the stay is for 1 year or 365 days, then also he becomes resident. To quote an example here, if the previous year was 21-22 and we will take only 60 days of stay in this year, and the 4 years, that block which immediately precedes this previous year, that is starting from April 1st, 2017 to 31st March 2021, if the stay has exceeded 365 days, then also a person will be becoming resident for tax purposes in India. So whoever is fulfilling either of one condition usually becomes resident for tax purposes. So let's see how to apply this basic two rules which are specified in Section 6 Clause 1 of Income Tax Act. Is it so simple that you will apply it in any circumstance and just categorize them as resident and non-resident? No. We have to look at 4 scenarios here. The first two, it emphasizes on the purpose of the visit and it is strictly applicable in the context of an Indian citizen. The third one is applicable in the context of any individual. So by this definition, it includes citizens and it may include foreigner also. The last one is about the deemed residency concept, which has been implemented after Finance Act 2020 and it is effective from assessment year 21-22. As I have discussed before, the first scenario involves the case of Indian citizen who is leaving country for taking up an employment. Now, employment means it may be anything. It may be self-employment, setting up of any business or taking up any kind of job. So, this involves all kind of scenarios. And we also have to stress upon one more point here. It is not necessary that the person is unemployed and leaving country in search of an employment. It may be possible that a citizen is already having a job or an employment with an Indian employer and leaving country taking some foreign assignment. So this involves these kind of cases also. Whenever an Indian citizen leaves country for employment purposes, the test to be applied is only one, the test A, which is 182 days or more. If it is more, they end up becoming resident. Otherwise, it's non-resident. The second situation is also focusing on the purpose, and it is applicable in the context of an Indian citizen. So whenever there is an Indian citizen who is paying visit to India, maybe to see his parents or any relatives, and for whatever the circumstances involved here, if the stay is exceeding 182 days or more, it is equal to 182 days or more, that means they end up becoming resident for tax purposes in India. It has happened during COVID with many NRIs. So here also there is a citizen who is visiting India and the test to be applied is only 182 days and more. Let me also emphasize on one more point here. This also includes OCI, Overseas Citizen of India. If he is paying visit to India and the stay is exceeding 182 days, then he also becomes resident for tax purposes in India. And the third scenario is involving the cases of any individual. So that might include even the foreigner. In this case, we have to see whether the test A, which is 182 days and more, or test B, which is speaking about 60 days in previous year and 365 days in immediately 4 years preceding that previous year, is fulfilled. If that individual is fulfilling any of that, he ends up becoming the resident for tax purposes. So now in the third context, what we have to see is whether the A or B, if either of the condition is fulfilled, they end up becoming resident. But in earlier cases, it was only test A, 182 days, which was applicable. Test B was completely not applicable and it was not functional in those cases. The last scenario is about deemed residency. It has been introduced by Finance Act 2020. It is mainly targeted at individuals who frame their stay in such a way that they do not become tax resident in any country and they are always escaping the tax liability. So in this case, what happens? If there is any Indian citizen who is residing outside the country and whose Indian sourced income, not foreign income, the source of income is from India is exceeding 15 lakhs rupees. Please note that the physical presence in India here is not 182 days. It has been brought down to 120 days or more. And he is not liable to tax in the country where he is presently residing by the virtue of domicile or any other reasons. In this case, they become deemed resident. So, even in the deemed residency, we have to remember that the status will be RNOR, which we are going to discuss later in the coming series. RNOR, resident not ordinary resident, will not pay tax on the global income. He will pay tax only on the income which is from Indian sources. So the same is true for the deemed resident. If one becomes deemed resident, he will end up paying tax only on Indian sourced income. So to conclude, there are also some other additional criterias and additional classifications also, which will lead to resident, not ordinary resident, resident, ordinary resident, etc., which we will take up in the coming series. I hope you like this video, and in case of any confusion lies, please ask me in the comment section. I will answer there.